I'd like each of you to take 2 minutes, 3 minutes, and run through what you think the most important things are that our attendees should leave today's webinar with. So, Matt, let's start with you.
Okay, thank you. Let me start with my remarks at the outset of the program, and that was when I talked about enforcement. I think the key takeaway on enforcement is that we're now in a world where the IRS has much more information than it ever did, many more data points, many more sources of information about taxpayer activities, both in the United States and abroad. And so the idea that you can hide from the IRS or you can hide assets from the IRS is really a relic of the past, and it's a dangerous proposition, and it's one that I think needs to be carefully. A taxpayer in that situation needs to carefully consider his or her options in terms of voluntary disclosure to come back into compliance, because the penalties for non-compliance are so severe, both criminal and civil. And then with regard to my second set of remarks as to willfulness, the weight of authority that's now being developed in the courts is, as I said, as I hopefully demonstrated, is very pro-government, pro-IRS, and anti-taxpayer, and it just highlights the critically important assessment that has to be made in every case of whether a taxpayer acted willfully or not. And that's something that we as practitioners have to do in every instance when we have a client who comes to us for advice. We have to undertake that assessment of willfulness with an eye on these recent cases and how courts consider willfulness, because that really shows that's the current state of the law that the IRS will rely upon when it undertakes its own assessment of willfulness.
As we said in the beginning, the landscape has changed from where we were 5 years ago, and it's going to continue to change. The important thing to take note is determining the path you're going to take by analyzing all of the facts and circumstances for your client, the taxpayer, regarding the undeclared foreign assets, and ensuring that you look at both the penalty side, maximum potential penalties that could be imposed, as well as the benefits from the program. One thing I forgot to mention earlier is under the new landscape, under the new program, it's not an if or doing the 2014 program or the streamline. Nowadays, it's one or the other. There's no turning back. So once they decide they want the criminal prosecution and later will opt out, they don't, not opt out, but to switch over to a streamline, they do not have that option. So it's very important to look at that willfulness side or those types of exposures and making the right decision for the client from all aspects. The time that's going to have to be invested, the amount of fees they will have to pay, as well as the amount of financial liabilities to the government that will come into play, and make sure that the client is comfortable with that decision.
And lastly, David Ganaway.
Yes, thank you. 2 quick points would be in the opt-out is to make sure you go through all of the potential penalties that could be assessed in the opt-out situation there. So that's really something to take into consideration, and the facts obviously drive the train here to see how likely you are in a reasonable cost situation to get some of the penalties abated. And the last thing in a criminal standpoint is for the people to realize that if the bank has already cooperated, the bank, and there's a case that Matt and I worked on together several years ago, we discovered that beyond the bank statements, which some of the taxpayers out there, some of the people that were involved in these schemes thought that the bank would only just be turning over bank records. Well, that's not what happens. There's certain cases where even if someone was going down to the local Kinko's to send a fax transmission over to one of the banks to say, please wire transfer X amount of money over to Bermuda this weekend because I'm staying there, they didn't think that would be an official record or anything that would be turned over. Well, the banks, if they the banks have been keeping those type of records, and that's been turned over to the Department of Justice for them to use and evaluate as a part of overt acts in a potential criminal case. So it's beyond the records that they've been receiving or telephone calls, conversations, memorandums, any communications outside of just normal bank statements. So you need to be aware of what all is being turned over by the banks.